Welcome to the Supreme Court of the United Kingdom, where we are beginning the third day of the hearing in the appeal of SC and others and the Secretary of State for Work and Pensions, which is concerned with the two-child limit on the payment of child tax credit, and the question is whether that limit is compatible with rights guaranteed by the Human Rights Act. We're hearing submissions on behalf of the Secretary of State at the moment by Sir James Eadie, and I'll turn now to Sir James.
My lords, my lady, good morning. I'm hoping you can all hear and see all right. I'm assuming so. I'm going to turn, if I may, to justification on the facts before turning to the bits about status and ambit and so on. And in relation to justification on the facts, the legitimate aims of the primary legislation were set out, as you know, in the Court of Appeals judgment, in particular at paragraphs 123 and 124. Those aims included at 1 in paragraph 123 of the judgment, reducing the budget deficit, and as part of that, reducing public expenditure on welfare benefits. My Lord Stevens asked yesterday about the £2 billion predicted figure, which I emphasise is a projected figure, but I think the answer to the question you asked is that it's an annual figure. The projection was an annual savings figure. You get that in particular from Mr. Higlett's statement at paragraph 49. You also get the fact that it's an annual figure from the quotation from the impact assessment in Mr. Justice Ousley's judgment at paragraph 34 on EF, that's the electronic file 264. And it might be worth just turning that up so you can see it in context. So
I was just wondering whether it is a ratchet figure, Mr. Eadie, insofar as when more children enter into the system or are excluded from the system, the figure increases.
That is true in terms of the amount, but it obviously depends on lots of other things as well,
yeah.
Including, no doubt, COVID or economic recovery or whatever it may be. It's not a simple exercise, and it's a ballpark figure. But if the basic point that's being made is it's a large number, probably within quite a broad range, the further out you go with the projection, the more things impact on it, then broadly we agree and positively rely on that. But if you go to 264, if you would, you'll see the quotation within paragraph 34 in Mr. Justice Ousley's judgment. And you see that that's a reference. And you see, in part, the reason for wanting to save money in the final sentence of that quote. So those are the aims, the broad aims are summarised in paragraph 123 of the Court of Appeals judgment. So far as indirect discrimination is concerned, I make no submission today beyond the analysis of Lord Justice Leggett at paragraphs 128 to 132 in relation to the justification for that indirect discrimination is those paragraphs we submit are correct. He then went on to consider the comparison between larger families and smaller families, if I can use that shorthand, at paragraph 133 and following. And he noted in that analysis that the focus when dealing with the larger versus smaller families was on why they were being treated differently. I flagged yesterday the possibility that when you're dealing with indirect discrimination, where the discrimination is simply, as it were, a functional byproduct of a neutrally phrased piece of legislation. There may be some debate about it, but normally the focus there is on the justification for the measure itself. But in relation to the larger versus smaller families comparison, that is the focus there is on why they're being treated differently. And so far as the various aims are concerned, the first one was reducing the fiscal deficit, which was dealt with in the Court of Appeals judgment at 134, and we've just looked at in the impact assessment. And Lord Justice Leggett recognised that that could provide a partial justification, as he put it. And we respectfully agree it's a relevant strand in the justification analysis. if you don't have a system that automatically expands or flexes irrespective of the number of children, it follows, and it follows from the projection, that money will be saved, and significant money here. But true it is that one could abolish benefits, as it were, for all and save more. But this is about the allocation of a non-infinite pot of social security. And it's a proper factor we submit to take into account in the justification that if you alter a system in this way, you will achieve savings, even if it isn't and wouldn't be sufficient on its own to provide justification, which is no doubt why the Court of Appeal referred to partial justification, because it would then allow you to just generate arbitrary distinction. So that's reducing the fiscal benefit. The second legitimate aim is incentivizing people to support themselves and their families through work. And in relation to that, we would simply note that, as the Court of Appeal correctly did, it applies to all recipients of child tax credit, but the incentive is a general. The state won't pay for this element of the social security payments payable to households for children beyond 2. So if a family decides to have 3 or more and decide that more money is needed as a result, that money won't be found in the state's hands, and that provides the incentive to work. The point isn't a terribly complicated one. And we also invite you to note, without turning it up, because it's unnecessary to do so, the points that we make in our case at paragraph 63 on electronic 154, which deals with the fact that the system is set up so that, as it were, any work results in money in your pocket. So those features are also important. But the broad incentivization point, we do respectfully submit, is a proper matter to take into account, albeit at that relatively basic level. The fairness aspects and the same financial choices as those who fund children solely through work are dealt with in the Court of Appeal's judgment at 136 and following. And again, we rely in relation to that essentially on the reasoning and judgment in the Court of Appeal's analysis, in Lord Justice Legate's analysis. The financial choices being similar or the same is correctly analysed, we submit, at paragraph 138 of their judgment. That then links to fairness and the broad fairness considerations for the reasons they set out at 139. And we essentially submit that 139 to 145 of their analysis is again correct. The overarching argument, as you're very well aware, is essentially that if you focus solely on the children or on children affected, whether all in the household or simply the 3 to 4 that come later in time after April 2017, it is, we agree with the Court of Appeal, to some extent self-evident that they or the household will get less under the system than they would have done before the change, precisely because the system doesn't infinitely flex in the way described. But the focus in relation to this sort of legislative change we submit is properly broader. This change did involve, as the Court of Appeal put it at 155 of their judgment, Parliament looking at legislation that treated families differently and making expenditure cuts on the ground of numbers of children in the family. We would note in relation to 155 one note of caution, perhaps, which is that we submit that there is no reason to shrink the margin or the area of judgment that we were talking about yesterday on the basis that the impact on the affected group, as opposed to children more generally, assuming that initial analysis is correct, that the impact on the affected group was not considered by the decision maker. I'm not going to go back on the points. You saw them additionally reflected in the note that we sent overnight, which I hope has reached the court, trying to respond to the invitation or the question that Lord Sales had asked yesterday. There are some more formal collations of material, but they tend to the same effect. Parliament does consider, not least in response to submissions from EHRC, the impact on the particular children who might be affected as a result of the change. But in the end, the broad area of judgment, for all of the reasons indicated when dealing with the principled approach, indicates that 158 of the judgment of the Court of Appeal, which was the subject of particular focus by both Mr. Drabble and Miss Mountfield yesterday, is plainly correct. There is ultimately, when you reach that point in the analysis, as Lord Justice Leggett pointed out, no sensible process of legal reasoning which can justify one view when you find down the analysis in that way as compared to the other. And in any event, the competing views were expressed and expressed very clearly during the passage of legislation. That is in no sense, I emphasize, an abdication of the constitutional responsibility of the courts. The courts, and in particular Lord Justice Leggett's intricate, detailed and careful analysis, examined the aims, examined proportionality, but properly did so when ultimately that question of balance was reached, allowing entirely properly constitutionally for that area of judgment to be left ultimately to the body most appropriate to make it under our constitutional arrangements, namely Parliament by way of primary legislation. So we submit that the analysis of the Court of Appeal, subject to some of those slightly fiddly points by way of caveat, is, we respectfully submit, correct. That's all I wanted to say about justification. Can I turn to Articles 12 and 8 direct before coming finally to the Article 14 initial bits about ambit and status? And I focus, for understandable reasons, I hope, on Article 8 direct. That's dealt with in the Court of Appeal's judgment at paragraphs 27 to 38. And again, our submission is that that analysis in those paragraphs was correct. There is no obligation on the state, as appears now to be uncontested, to have in place a positive programme of financial support for private or family life. That was the court's conclusion correctly at paragraph 30 in Lord Justice Leggett's judgment. It had been rejected as a proposition, i.e. the positive obligation, consistently in Strasbourg. Petrovich is normally the classic authority cited for that purpose, where the proposition is stated very clearly and boldly before moving on to ambit as a matter of direct engagement of Article 8. At paragraph 26, electronic page 4110, Bundle 9, tab 93, and old money, referred to in the judgment of the Court of Appeal at paragraph 31, but also, and as importantly, not least because, as was pointed out by someone, or has been pointed out on a number of occasions, this statement could have been a statement of a chamber of three in the Supreme Court, from T.G. and Lambeth. That's the citation being paragraph 33 in the Court of Appeal's judgment. I don't think it's found its way into the authorities, but all you need is in the citation or the quotation at paragraph 33 of the judgment, to which one could add, if necessary, Lord Hughes in S.G., the first capping case, at paragraph 139, page 1414. So no positive obligation on the state. The Court of Appeal then rejected the argument that had been mounted that the aim of the two-child limit was to discourage families from having more than two children, and that directly engaged Article 8. They concluded correctly, we submit at paragraph 35, that the premise for that submission was wrong. That wasn't the aim of the legislation, referring back to their analysis of paragraphs 23 to 24. And in any event, they concluded, even if the premise had been right, it wouldn't justify a conclusion or the conclusion that the appellants contended for of direct engagement of Article 8. See paragraph 35 of the Court of Appeal's judgment again. So the appellants have shifted their ground somewhat and now say, well, the efficacy of the legislation depends on the ability of individuals to respond to its existence, to which we respond, but we're not entirely sure how. The efficacy of the legislation and of achieving the aims that I've showed you already correctly identified in 1, 2, 3 of the Court of Appeal's judgment depends on the removal of the flexing of payment beyond two children. If you have more children, you simply don't get paid that element of the social security payments that otherwise went to the household. And in any event, for reasons I don't dwell on, we've dealt with them in our case at paragraph 9, it is far from clear on the evidence we submit that the impact of the legislation will be fewer children born to families who might otherwise have claimed. The Court of Appeal in this regard, in relation to direct engagement of Article 8, also rejected the appellant's reliance on the Botter case that you went to yesterday. They did so at paragraph 36 of Lord Justice Legate's analysis. Botter itself, if you need it, is in the first bundle of authorities at 1450. And it was, I would remind you, a complaint which was not even found to be within the ambit of Article 8, despite the pressing, it might be thought, and socially engaging facts of the case. But they relied on the statement of principle in Petrovich, paragraph 26, which I've already referred you to. And we've also included in our new bundle of authorities, supplemental bundle of authorities that went to, I think, the day before yesterday, we've also referred you to Sentgiz and the Netherlands. It may be very difficult to keep up with all the electronic things you've been sent, but if you can find that additional bundle of authorities and find your way to page 191, I just want to identify the passage we rely on. So it's supplemental authorities, which should be in a PDF document.
Yep.
Page 191, and the paragraph I want is really the final paragraph on the page. Halfway down that final paragraph on page 191, I pick it up halfway through the line just after the citation of Botter, second citation of Botter. The court has also held that Article 8 cannot be considered applicable. Can I just invite you to read that bit to the end of that paragraph, which flows over the next page. And it might be thought that that passage, with its idea of relative interference, if I can put it that way, and the need for something exceptional that really seriously impact in that way, leads one perhaps into my learned friend Mr. Drabble's reliance on the Marks case. As you recall, in opening the appeal, he relied on the Marks case, particularly the passage at paragraph 31 on electronic 3775. My respectful submission is that that doesn't assist him here. And it doesn't assist him here because that case was all about, and the analysis in that case was all about legal safeguards, as it was put in paragraph 31, to render possible a child's integration into the family. It was that that unsurprisingly engaged Article 8 directly, because well recall that case was all about stigmatizing illegitimacy. Here one is just dealing with a different question about the overall amount of social security payments for households and whether the state is required to pay at a particular level. The problem of resources being stretched by additional children is, after all, not uncommon. But there is no proper parallel, we submit, with the position factually in Marks, and the statement of principle that my learned friend relied upon simply doesn't assist him on the facts of this case, although entirely unsurprisingly, it did lead to the finding of engagement in the Marks case. So that's what I wanted to say about Article 8. Article 12 was, I think, hardly if at all mentioned in oral submissions. It is about the right to found a family within marriage. There's nothing about the provision of financial assistance in respect of all children in the family, however many children you may have, or social security having to respond in that way, irrespective of all the other elements in it and the setup, so far as family life is concerned. So I repeat, the short submission in relation to both direct engagement of A8 and direct engagement of A12 is the same. The Court of Appeal got it right, essentially, for the reasons that they gave. And the only reason I think that Marks was not referred to is because it wasn't majored on by my learned friend in the Court of Appeal. But I've given my response to the Marks case. So that's direct engagement of A8 and A12. Can I turn to the vexed and difficult issues of ambit and status, if I may? So far as ambit is concerned, and we're now, as you will be aware, we're now in the A8, A14 or A1P1, A14 part of the analysis. And the basic principle, which you're well aware of, is that even though you don't necessarily have to establish a breach of either of those two articles to fall within the context of article or the ambit of Article 14, you've got to show that the nature of the discrimination is at least within the broader penumbra that is marked by the principle of within the ambit. So it doesn't have to be a breach. The degree and nature of the connection is the question. We respectfully submit that the analysis of whether or not something interferes or engages is at the very least an indication, and probably a pretty powerful indication, as to whether you are or you aren't within the ambit of Article 8. And as I think Lord Reid might be thought to have at least suggested in paragraph 79 in his analysis of that issue in the SG case, electronic page 1397. And the test for the link required focuses on the nature and purpose of the benefit in question. This is a pure income benefit in terms of the payment of the benefit, but we do submit, it's a short point, there has to be a question of degree involved, severity, as it were, of impact. You don't just look at the benefit in question and say, well, there we are. And we do recommend and submit that it's useful to go back to the days when these issues were first being analysed, in particular to the speeches in the M case, M for mummy case of Lord Nichols and Lord Bingham. If I can invite you to go to M, it's in bundle 4, tab 45, and it's electronic 2157. Lord Nichols, first of all, if I may, at paragraph 14, 1.4, on page 2166.
I'm sorry, which paragraph?
Paragraph 14, my lord, I'm so sorry.
Thank you.
Page
Not at all, my fault.
Yeah, 2166, para 14. So that's a focus in effect on relative impact, not just any tenuous connection, but relative impact on the values underlying the particular substantive impact. To what degree is their impact? That is the relevant question in relation to ambit. It doesn't determine how it works in a particular case, but as a proposition of principle, we respectfully submit that that's at the very least helpful. It was, I think, that paragraph that was referred to by Lord Wilson, you might note, without perhaps quoting it, in the DA case at paragraph 35, electronic 1270. That was the passage that he referred to, but it's worth going back to it in the raw because you see the full flavour of it. And that is to similar effect in terms of an approach we submit to the approach that Lord Bingham sets out in paragraph 5, that's 2165 within M. So paragraph 5, Lord Bingham effectively applying that approach. That's the M case. The Court of Appeal's reasoning, to bring it back to our case, the Court of Appeal's reasoning was that you fall within the ambit here, they said, of Article 8, simply and without more, because a CTC is payable to a person responsible for the child to provide financial support for families with children. I'm never very sure whether modalities actually helps the analysis, but that appears to be the thinking. But the concern with that analysis, that you simply look at CTC being payable as one of the mechanisms of supporting families with children, is that it is broad to the point where ambit really becomes pretty meaningless in the context of social security. Many, if not most, if not all, payments made under the social security regime in all its infinite complexity are paid to support households including children in need. And it can't be right, we submit, that every reduction in a general income benefit is automatically within the ambit. If it were, that would, in truth, make obsolete the relative question analysed and posited by Lord Nichols and Lord Bingham in M. And here we are in the sphere of general income-related benefits, and one does need the precision of analysis of the kind later seen in the Court of Appeal's judgment. This isn't a measure aimed at children generally. This is really about the amount of money that goes into households. Although, of course, one can analyse it at one level as being about payments in relation to children, but this is ultimately a judgment about payments to household. It doesn't interfere with Article 8 for the reasons I've already given and the Court of Appeal accepted, and that should be taken as a strong indication that there's at least a very big flashing light above ambit as a question. Article 8 doesn't guarantee or entail any positive obligation to provide social security at any particular level. And we do submit ultimately, therefore, that the Court of Appeal's reasoning, which reduces ambit effectively to nothing across the range of social security, is not the right way to go. Lord Nichols is the way to go. You ask the relative question, and we respectfully submit that if you do it in that way, there's at the very least a much, much more serious ambit question in relation to Article 8. So that's Article 8 and ambit. That's a short point on that. Article 1 of Protocol 1, again, the point is a short one, but a slightly different one. And normally, as you're aware, if you've got a social security entitlement, you have an A1P1 possession, precisely because you have an entitlement under the social security legislation. As Lord Wilson noted in the first benefit cap case, SG, paragraph 60, page 1391, there were two ways of analysing the cap. It may be worth just turning that up briefly. So 1391 in bundle 1, tab 12, paragraph 60.
I think this is actually from my own judgment. I don't think Lord Wilson sat in that case.
My lord, I'm so sorry. I've got it wrong. It is from your judgment. You're right. That distinction that I was interested in. I'm so sorry about the attribution. It is paragraph 60. So the question here is whether our provisions are a rule preventing them from having any possession. And our submission is that the analysis of Mr. Justice Ouseley at first instance, at paragraphs 89 to 93, is powerful. Electronic page 280. Don't invite you to turn it up now, but we do submit that that's a powerful analysis in relation to A1P1. And I won't do it justice by the summary, but the position we submit is that if a state provides benefit, it must do so in a non-discriminatory manner. And it isn't answered by saying, well, we have no obligation to provide the benefit. So if the benefit is available, as it were, there's an entitlement to it, and you were to say, well, that's a benefit that's available only to white people, not to black people, or only to women and not to men, or vice versa, then there would obviously be problems. But it doesn't follow that the fact that the benefit might have covered a particular group of people in the past, it is altering the current scheme automatically operation within the ambit of Article 1, Protocol 1. I could put the same point a slightly different way. The current scheme doesn't create an implicit promise of forever continuation. It's not enough to say that at some point in history, the benefits regime covered this particular aspect. If that is enough, then within the ambit of A1P1 ceases to be a real requirement at all. And we know from cases like Vrontu, Bundle 10, tab 99, page 4251 at paragraph 63, that A1P1 does not require benefits to exist at any particular level. The principle is rather, and at most, that if a state continues to provide benefit of a particular kind, it can't do so on a discriminatory basis. The A1P1 link is provided by the continuation of the benefit. And the key feature here is that the legislative scheme has changed so that, subject to transition and exceptions and so on, no one can now make a new claim for CTC for the third child. So no one gets the benefit. That was the punchline of Mr. Justice Ousley's analysis at paragraph 91 of his judgment. As he put it, the need to which the benefit was addressed goes unmet for all. But true it is that without the legislative change, claimants would have become entitled, but that can't be a possession or anything remotely like a property right, because they could have no legitimate expectation that the benefits on which they might wish to rely would remain unaltered. So we respectfully submit that for those reasons, essentially reflecting the reasoning of Mr. Justice Ousley at first instance, again, there is a much more powerful case that this falls without the ambit of Article 1 of Protocol 1 already, and in any event. Status is the penultimate topic in my submissions. The core principles are well known, and I've often cited them, and by and large, by the time you get to the end of the core principles, it might be thought you're not really any the wiser. But I set them out in any event, just because they provide the premise or the springboard from which the really meaty analysis then flows. Perhaps it's worth noting four, if I can do so without boring or frustrating, in particular, Lady Black and her detailed analysis of this issue in the Stott case. Firstly, it is not every difference of treatment that falls within the scope of Article 14. The structure and express terms of the article make that plain. In particular, if other status was intended in effect to be a catch-all list of specified grounds, then the specified grounds would be pointless. The difference of treatment has to be on one of the specified grounds, or on the ground of something that can properly be characterized as other status. It's an article which, in this respect, I think I cited in Stott Lady Hale in AL Serbia, that you have in the bundle at tab 37 of bundle 3, paragraph 26, page 1854. It is, as Lady Hale put it, open-ended, but evidently not endless. See also for that purpose the Stott case in Lord Mance's judgment, bundle 6, tab 63, at page 228, 3044 in the electronic. Secondly, geographically within the article, other status sits at the end of the list. And that structurally strongly implies that it was intended to operate a justem generis. The meaning of other status and or its application should therefore be shaped by the analogy with the specified concepts that are set out in the article. Thirdly, it was no doubt that thinking which shaped the identification of the concept that lies, and it might be thought should still in principle lie at the heart of the grouping, personal characteristics. That concept was considered by the House of Lords in the RJM case. It was considered by Lady Black in particular in the Stott case at paragraph 54, electronic 2995. And it was that case that brought about the important simile of concentric circles, Lord Walker's famous concentric circles, important because it recognizes that there is in fact an outer circle. So we submit that personal characteristic should be the guiding test. And those concentric circles are important both because they go to the reach of other status, there is an outer circle, and also as assisting the analysis because even if you're within the outer limit, that goes to the ease of justification and or the breadth of margin or area of judgment. Fourthly, we submit that there is still a live question post-Stott as to whether status can be defined in effect solely by reference to the difference of treatment complained of. In the Stott case, all the members of the court, except Lord Culmouth, were against us on other status covering the prisoner in question, especially in the light of directly applicable authority from the European Court of Human Rights. But it's by no means so clear-cut on the principled approach to be applied in that to that question. The judgments in Stott I'm not going to go through again for the purpose of this morning's submissions. Both parties made in this case submissions about the impact of the Stott case to the Court of Appeal in supplemental skeletons. And can I refer you to ours in relevant part, particularly on this point about bootstraps and relying solely on the difference of treatment created by the legislative scheme in question? Can I refer you to our Court of Appeal supplemental skeleton addressing how those issues were dealt with by the Supreme Court in Stott, paragraphs 10 to 17 of our supplemental skeleton, which is in Appendix Part 2, electronic 410 to 412. So in a nutshell, and I hope we've analysed it correctly, Lady Black dubitante at paragraph 74, but her conclusion being much softer than rejection. Lord Carnworth disagreeing entirely on other status anyway, 175 to 179 of Stott. Lady Hale, the core principle, being in the last sentence of paragraph 210 for this purpose. Lord Mance at 235, effectively saying you can't create status by pointing to mere difference, his first sentence of 235, but you could have a situation where that ultimately corresponded to something which would otherwise be status, but analysing the position by reference to the particular facts of the prisoner in that case. Certainly not a full-blown acceptance that you can haul yourself up by your bootstraps and create status thereby by relying simply on the distinction drawn by the legislation. And again, Lord Hodge, if we've understood his analysis correctly, simply analysing it on the basis of the position of the particular prisoner and the difference that was being dealt with in that case. So we respectfully agree to go back to the Court of Appeal's treatment here. We respectfully agree with much of what is in paragraph 67 of the Court of Appeal's judgment. Electronic 219, 67 of the Court of Appeal analysing Stott. But their conclusion ultimately was that being a member or a child member of a household that includes more than 2 children is a relevant status, but isn't a suspect relevant status. See paragraphs 77 to 78. And it's really only the first bit of that that we quibble with. And we do so on the basis that there is real concern about the breadth of this concept in the context of social security, whose rules and distinctions will inevitably be expressed in broad terms and will inevitably affect different groups of people differently. That is, as it were, in the nature of social security legislation. That was, I think, the point that was being made by Lord Hodge in the DA case at paragraph 126, electronic 1295. And here we submit, being a member of a household with more than 2 children, when it's analysed in that way correctly, as the Court of Appeal did, that's the grouping you should be focusing on, is a status of significance really only because of the boundary set by this social security legislation. Being a member of a household with more than 2 children doesn't have other significance. And the Court of Appeal's analysis at 276 is, we submit with the greatest respect, pretty loose. They describe it as being a feature of persons' circumstances or living situation on which a legal consequence depends. I take that from paragraph 76 of their reasoning. But that effectively means everything. We wouldn't be having the argument unless a legal consequence depended on the grouping or the feature. You can't legislate on the basis of features that don't exist already in some way. But if you define it that broadly, you are in essence creating, it might be thought particularly in the social security regime, you are in effect creating a principle whereby everyone's within it, because a legal consequence will always be dependent upon the grouping in social security terms. That's how social security works. So you just eradicate the feature, and that can't be right, we submit. And it's for that reason that we again respectfully invite the court to consider Mr. Justice Ousley's analysis at paragraph 125 and following. And we do so on the basis that the Court of Appeal's analysis is simply too loose, because it does involve, in effect, saying, well, whenever you create a grouping on which the legal consequence of entitlement or otherwise under the social security regime depends, there is your the status for present purposes, and that is intensely problematic, we submit, because it doesn't identify anything other than the fact that the legal regime prescribes a consequence, and that's enough for status. Alternatively, and in any event, we do submit that they were right about, on no view is it a suspect characterization or status when you come to analyze the thing realistically in the context of this social security regime. And we submit that paragraph 78 of the Court of Appeal's judgment is plainly right in relation to that. And so too, this is the core of the analysis of the Court of Appeal in this respect, so too is the reasoning at 155 of the judgment. The difference is in the treatment of families on the ground of the number of children that they choose to have. But no doubt true it is, and of course it is true, that children are not responsible for being born, but their existence and their subsequent welfare, as the Court of Appeal analysed it, inevitably depends on parental choice. There is an intertwining of interests here, inextricable intertwining of interests here. And as they put it in 155, arguments based on the interests of children are not a trump card that render arguments based on what is fair to other taxpayers irrelevant. And we do recommend and support the analysis of the Court of Appeal at 156 to 157. This does not involve penalising or blaming children for the acts of parents. Lord Hodge's identification from the UNCRC in the Zumbas case. That's simply a contentious and, we submit, inaccurate way of describing the change. That principle, that approach, does not preclude changes to the social security system on the basis that you've seen. That leads to the final topic, which is differential treatment. My lady, sorry.
Can I just go back to this vexed question of status, please,
Yes.
and to ask you how all this fits if we looked at the French version of the provision, which I think I recollect correctly, says ou toute autre situation, which is incredibly broad.
Well, my lady, I think the answer to that is that the points about structure that I made remain. And the court in Strasbourg has not treated this as being endless. So it isn't the literal French translation, as Strasbourg has acknowledged. So the real question is not, is there a limit? There plainly is, and that is uncontroversial. The question is where that limit lies.
I suppose that I'm specifically asking it in relation to what you term the bootstraps argument.
Well, my lady, again, in the context of social security, it can be toute autre situation, if you will, but there is still a question as to whether or not you can, as it were, create status purely because legislation exists and creates a legal consequence, which was the approach of the Court of Appeal. I fully appreciate that all of these things are to some extent impressionistic, and there isn't any clear binary answer. It's all a relative question. But I do submit that the way that the Court of Appeal addressed it, which is simply to attach status to the idea of legal consequence, would be to remove the debate entirely in the context of social security, which has the features that Lord Hodge identified. I don't suggest that precisely where one draws the line, recognizing that toute autre situation cannot be endless, is an easy question, but I do submit that it is very, very difficult to create a principle which isn't endless if you adopt either bootstraps or the expression of bootstraps in another form, which is the Court of Appeal's analysis.
Thank you.
That leaves me only with differential treatment, and the only real question there is whether this is to be regarded as a comparison involving children generally. And we respectfully submit in relation to that the Court of Appeal's analysis at paragraph 81 of its judgment was correct. Benefits here are payable to adults. Part of the calculation is the size of the household. Where additional adults join a single adult household, the amount of the increase is not to double the single person amount. It goes up by, I think, approximately 25%. If you're dealing with adults, the position is truly not comparable in relation to all children. Lady Black, I think, asked the question earlier in my learned friend Mr. Drabble's submissions about whether the way of looking at this was all people in the system who are reliant on benefits have an amount attributable to them for subsistence, except for children to whom the limit applies. And so far as that is concerned, of course, on one conception of it, that is right, because the way the thing is structured is that there were amounts attributable per child, as it were, under CTC, so it operates in that way. It is correct, but it is at least worth noting in relation to that, so far as subsistence is concerned, benefits are not calculated on the basis that they are designed as an overall amount for families in need to provide, and indeed subsistence basis also, at the basic minimum subsistence level. That is dealt with in Mr. Higlett's statement at paragraph 78 and 79, EF 585, and in our case at paragraph 14, there is an amount of money available to the household based on all of its circumstances, and that is the envelope within which parents have to decide whether they can support more children. As I say, true it is that the basic amount that a single household adult will receive will increase by a limited amount if another adult joins the household, but if an additional child joins the household after that, there's no additional amount payable. But our point here is that the position of adults and children within that benefit system are simply not analogous. And you have to correctly analyse it, as the Court of Appeal did in the judgment at paragraph 81. So that's what we say about analogous treatment and differential treatment. And my lords, my lady, unless there were any further questions for me, those are my submissions on behalf of the Secretary of State.
Well, thank you very much, Sir James. I think we can turn then to Mr. Drabble.
Yes, I hope the court can hear me, and I
Yes.
start on my reply. Thank you. I want to fundamentally concentrate in the reply on the issue of justification, and partly in response to my Lord Stephen's questions about getting the broad picture that is in front of the court as clear as I can in relation to the various arguments on justification. So there are two strands to the submissions on that task. The first is, what is the objective picture that the court can now see? And secondly, how was Parliament invited to deal with that objective picture? What information was available to Parliament? And in particular, what approach did the minister responsible for the bill invite Parliament to take? I use the phrase, the minister responsible for the bill as a deliberate echo of the concept in section 19 of the Human Rights Act, which I'll come to in due course, as possibly a principled answer to the questions that arose yesterday or the day before about how to approach Lord Nicholl's judgment in Wilson and Firth County, because the minister responsible for the bill does have a particular status when it comes to dealing with issues of compatibility. First of all, what is the broad picture? Your Lordships and my lady now have, first of all, our note, which we put in overnight. There was an answer from the Secretary of State. I say there are some comments on our note from the Secretary of State. That was dealing with the analysis in Lord Justice Legate's judgment about the size of the impact on individual families. Your Lordship and my lady will recall. Dealt with that at paragraph 153 of the judgment at EF 243. So without spending time on the detail, it is crystal clear that the change to the introduction of the two-child rule did have an impact of the scale spelt out in the judgment of Lord Justice Legate at 153, and essentially meant that households affected in the way described in the judgment and in our note would have a standard of living reduced to basically something equivalent to asylum support levels. What's the size of the impact in terms of numbers affected? If the court will look at EF 158, we are in the intervener's case, Mountfield client's case, and after the figures that are contained in paragraph 4, in footnote 4 at EF 158, and the footnote states that are based on the DWP's latest published figures on the 2nd of April 2020, 911,000 odd children in 250,300 households were already affected by the measure. That's by the 2nd of April 2020. A joint report by the Child Poverty Action Group and the Church of England, published in May 2020, estimates that even without allowing for the effects of the current COVID-19 pandemic, 2 million children and 600,000 families will be affected by this measure by the end of this Parliament in 2024. So we are dealing, well, Lord Sales has his hand up.
Sorry, finish your point and then I'll ask my question.
The sentence, and so we are dealing with an effect of the, in financial terms, of the scale recognised by Lord Justice Leggett in the paragraph, the judgment I've taken your lordship to, across potential 2 million children affected by the end of the Parliament in 2024. My Lord.
Yes, sorry, I just wanted to ask about page 6H1 in the impact assessment that was prepared for the bill, paragraph 24, where it looks at the longer term impact and says once the policy is fully rolled out, approximately 3.7 million households will have a lower rate of payment. And that those figures are large, and one might think are broadly in line with the information that you just referred us to. What do you say about that?
Sorry. 681, I'm sorry.
Yes, I'm sorry. Page 6H1.
I'm sorry, I'm just being slow. It's the top of page 681.
That's right.
4 and 25. Yes, I think they are. I mean, they are broadly in line. I think that's probably right. I dispute that.
So I'm just going back to the debate that we had yesterday with Sir James, and what Lord Nichols said at paragraph 62, I think it is, in Wilson, that one assesses the proportionality of a measure at the time it falls to be applied, but also noting that there may not be a relevant change of circumstances from the time that Parliament legislated. Would it be fair to say that Parliament legislated appreciating that the scale of the numbers affected were, as they have been affected in fact, as shown by the intervener's footnote 4?
It certainly legislated on the basis of the impact assessment, and that I accept. I have to accept that, and I do accept that. There is another report, select committee report, not in front of the court, about how the rule has actually been functioning, which postdates the enactment of the legislation. But simply in terms of the numbers, your lordship is correct.
Yes, thank you very much.
But we do therefore have a very significant impact. We'll come back to how the parliamentary material was dealt with during the course of the enactment of the legislation in due course. Well, relatively shortly, actually. But against that background, that basic background, where do we now stand in terms of the proportionality arguments that are now run? First of all, if we look at the position of children as a class, we dealt with this in paragraph 111 of our printed case. Which your lordships and the lady will find at EF 121. Dealing with children generally, Court of Appeal, as we after the submission in 111, is the Court of Appeal did not consider justification in relation to children as a group because it held there was no differential treatment. However, it's clear that the differential treatment cannot be justified. Neither the fairness nor the financial incentivization aims have any relevance to children who have no control over these matters. Two issues cannot constitute legitimate aims in relation to the discrimination against children. And we stand by that submission. If once one has seen that the impact of the change in the rule is targeted or affects children by removing the amount that's payable in respect of their subsistence benefit, then that impact on the children can't be justified by a aim which is only related the two aims of financial incentivization or fairness to the behaviour of the parents. So that's the first point about where we now have got to. In any event, we say, looking again at justice children as a class, our case at paragraph 119 picks up what we say are two obvious weaknesses in the justification that's said to be put forward in argument about the impact on the children. First of all, the proposition put out in 118, immediately above 119, that the government's aim was a desire to ensure families in receipt of benefits are encouraged to make the same financial decisions as families supporting themselves solely through work. We say that's just simply an unreal way of looking at it. The contrast is with the way the Secretary of State puts it in his printed case. I'm just ask the auditor to go to that too. Paragraph 10 of the Secretary of State's printed case, which the Lordship and the lady will find at EF 136 over to EF 137. So sort of EF 136 and 13 over to 137. The court will see that at the very foot of the page, 4 lines into paragraph 10, Secretary of State characterised our case on this basis. In reality, he says, the appellant's case on this issue amounts to an assertion of a positive obligation in the state to relieve a prospective parent of any need to consider whether they are financially in a position to support another child. But we've tried to explain that that is a wholly unrealistic way of looking at it. People who are at the subsistence end of the spectrum covered by either CTC or universal credit are obviously in financially straitened circumstances. By definition, they're on means tested benefit with no surplus above the amount provided by the benefit. It is obvious that any decision to have another child will involve, whatever the benefits regime in terms of additional amounts, will involve increasing the financial pressure. Choices, there's no question of the parent being relieved of any need to consider whether they are financially in a position to support another child. They will have to think about that if they are thinking about it at all. Because if they have another child, their financial circumstances will be under pressure. The contention, therefore, in paragraph 41 of the note to the JCHR, which I'll come back to in a moment, set out by us in paragraph 118 of our case, that families in receipt of benefits are encouraged to make the same financial decisions as families supporting themselves solely through work, is just unreal. A family with a surplus above CTC or universal credit levels, supporting themselves solely through work, is in utterly different, completely different financial circumstances. And we say, therefore, that the basic aim basic fairness aim as applied to children, in fact, whether the children as a class or the children in households of or with three or more children, just doesn't work because there is no issue, there's no possibility of the families in work not needing CTC facing the same financial pressures as those who are on benefit. The basic analysis doesn't work, basically. And secondly, the second point in 119 is that there will be a class of cases, a significant number of children born in circumstances to which the choice of gender just doesn't apply. As we say in 119, as pointed out in paragraph 64 above, only a minority of third and later pregnancies are actually planned, the majority or not. The inevitable practical consequence of this feature of real life is that, well, let me spell it out, either you're born in very straitened financial circumstances, or the child has to be aborted. In the real world, this consequence of the policy cannot be ignored. Those are aspects of the objective situation as they affect children. If we go on in the case to draw attention to what was stated in DA and DS about the impact of poverty on children, paragraph 122 of printed case EF 124, can I take the court back to the full context for that citation in DA? If your lordships really go to EF 1269, which is at volume 1. Volume 1, tab 9, 1269 is full quotation from Lord Wilson, again part of the objective situation. Does the revised cap inflict poverty? This is at the foot of the page, paragraph 33, foot of 1269. Does the revised cap inflict poverty on those subject to it? The answer is hotly contested. But since the government cannot sensibly argue that the computation of welfare benefits is intended to provide a family with more than it needs, it follows that a reduction of those benefits will provide it with less than it needs. Of course, the concept of needs is to some extent elastic. It can be assessed with somewhat greater or lesser stringency, but the government does not seek to argue that the lower figures set for the revised cap have been reached by reference to any scale of needs. Equally, in the speech in 2016, then we are getting into the quotation that is set out in our printed case, which your lordships have seen already. Paragraph 34 goes on to say that we choose striking evidence adduced on behalf of the DA appellants about the effect of children of life of early about the effect on children of an early life in poverty, with the quotation which we set out in the printed case elsewhere about the long-term impact of early childhood in poverty. So all of those are objective features of the background. And the next set of objective features are that there will be many children in affected families to which the same choices or fairness aims are simply irrelevant. And we've set out the reasons for that, which are obvious, at paragraphs 132 and 133 at EF 127. And it's the heading above 132 says it all. The changes affect a large number of people who are not on benefit when making a choice. So that you imagine the family who do think about financial consequences having an additional child. They are at that stage in work. They may be very comfortably off, they may simply be comfortably off. But then they hit straitened circumstances, and the result is immediately that they become subject to the two-child rule in circumstances where the justification for it, the choice justification for it, has no conceivable relevance. And paragraphs 134 to 136, the other aspect of that, which is basically the second half of the what we have dealt with in 119 infantry case, in addition to the people who are affected by the rule when they were not on benefit and making a choice to have their younger children, number of people who do not make a choice about having children because of the circumstances of conception spelled out in paragraphs 134 through to 136. So we say, stopping there, and without any impact into the analysis from Article 3, there is a major issue about whether the effect of the two-child rule in the various ways I have described is proportionate, and the impact on the groups that we have identified is proportionate. I've dealt so far solely with children. And moving on to the separate issue of the impact on women, I'm obviously keen that the court appreciates that the issues I raised about the impact on women in the submissions I made about the direct engagement of Article 8 apply to discrimination against women and the justification argument that comes into play there. And that's what we have said in paragraphs 69 to 72 at page 10, at EF 107 of our printed case. Court of Appeal dealt with this, and my own friend this morning referred your lordship, my lady, to it at paragraph 126 of the judgment, which is at EF 236. And your lordship will see the logic that Lord Justice Lockett spelled out, but with which we profoundly disagree. That 126 says, not in dispute that the two-child limit has a disproportionately prejudicial effect on women. This results from the fact, as the judge found at paragraph 108 of his judgment, and then the statistics about numbers of lone women, lone parents, which are women in one-parent families, put out. And he says there that it follows, he says, the fact that the two-child limit affects more women than men is therefore not a feature peculiar to this particular measure. It's a consequence that any reduction in any child-related benefit would have. It would apply, for example, to a single reduction in the amount of the individual element of child tax credit to the abolition of the family element, so on. But that's the logic which we don't accept. If your lordships would go back to 69 to 72 of our case, we spell out why. It's page 107 of the EF 107. And the core of it is in paragraph 72. Well, it's 70 read together with 72. Paragraph 70 contains the contention that the two-child limit is uniquely structured in comparison with other possible social security measures of equal aggregate financial impact, directly links a cut in the per capita benefit entitlement with intimate personal decisions that give rise to increased household subsistence needs, concerned with whether to start or continue a pregnancy. And then the submission I'm now making is the first part of paragraph 72. Court of Appeal noted, paragraph 126, the financial effects of any reduction in benefit expenditure on children would affect women more than men, with early moving from that proposition to the conclusion that no less discriminatory measure would achieve the same expenditure reducing aim. Further take into account the financial effects, which are distinctive about the two-child limit, and which directly and necessarily affects men and women in a way in which men are not affected. And that discriminatory feature, we submit correctly, I say, is not shared with other money-saving measures. So the analysis of the Court of Appeal has left out of account a central part of the impact of the analysis on women. So now we move from that to how Parliament was invited to deal with that. Well, we now have Secretary of State's, we have two documents now from the Secretary of State, the table that went in yesterday, I think, various quotations from the material. I'll come back to that in a moment. And summary in paragraph 3 of today's note of the documents that were that are additional to the table handed up yesterday, paragraph 3 says. Now, what do we do with all of this? My submission, that question of what we do with it all is capable of a principled answer. Your Lordship, if I could invite your Lordships to go to section 19 of the Human Rights Act, your Lordship or my Lady will find it at 1527. And the wording is actually important. It's statements of compatibility. 19.1, a minister of the Crown in charge of a bill in either House of Parliament must, before second reading of the bill, A, make a statement to the effect that it was in his view the provisions of the bill are compatible with the Convention rights, a statement of compatibility, or B, make a statement to the effect that although he's unable to make a statement of compatibility, the government nevertheless wishes the House to proceed with the bill. Statement must be in writing and be published in such manner as the minister considers appropriate. So, in putting that statutory provision together with the speech of Lord Nichols in Wilson, we immediately see that there is a concept, statutory concept in the HRA of a minister in charge of a bill. He is required to explain to Parliament why it is that he considers that the bill is compatible with Convention rights, if this is a 19.1a case. Applying the logic of Lord Nichols, we say that if one is looking for the correct description to be imputed to Parliament of the approach they took to the proportionality of the measure, one goes to the statements of the minister in charge of the bill. There is an analogy. I recognise that Pepper and Hart is concerned with interpretation of a different constitutional issue in terms of the relationship with Article 9, but there is a relationship between the concept in Pepper and Hart of a statement being made by the promoter of the bill, and the HR. I'll just finish the sentence. The statement here, where It's not the promoter of the bill, it's not language, it's the minister in charge of the bill. There's an obvious parallel with all your says.
Yes, I'm having some difficulty with this submission because section 19 just requires the minister to state his own view on a particular matter. It doesn't give him authority to speak for Parliament, and very clearly he doesn't have that authority. And Lord Nichols in Wilson made it very clear that the question when one's considering proportionality goes very much further than material put before Parliament by the minister in charge of the bill. It takes account of material put before Parliament by anyone. And obviously, members of Parliament may have their own views about whether the provisions of a bill are or are not compatible with convention rights. And they have to vote on it.
Your Lordship is obviously correct. The question is, what does one do with that thought? If Wilson is, it might be helpful to have Wilson sort of in our minds or open at the point of the debate. Wilson is at EF 3248, or at least the relevant passage is at EF 3248. It's in old language, bundle 7 of the authorities bundles, 3248. And passage runs through to 661 to 67. Now, certainly, paragraph 64 says that the courts must be able to look at additional background material to be found in published documents such as a government white paper. I'm sorry.
I think I may have been muted at that point. I was just inviting your attention to the second sentence of paragraph 64.
Yes, I know, that's what I was
making it clear that one doesn't look to a minister as speaking somehow for Parliament. You look to any material that is before Parliament.
Well, what you don't do, I will come back to this when we come to the material the Secretary of State's now put in. What you don't do is engage, as we debated yesterday, I think, is engage in the exercise which Lord Wilson won't contemplate, set out in paragraph 67. You don't look at the nuances of the debate. So the position in my submission is this. You have here a ministerial statement under section 19. It's given by somebody who has the status in the machinery of the Human Rights Act to make that statement. It's obviously prime source of the sort of material that Lord Wilson is talking about in paragraph 64. You then look at the materials that the Secretary of State is now inviting the court to look at. If I can just illustrate the point, first of all, if your lordships and my lady have an offence table that went in overnight on the first day, I think.
Yes, obviously I'm not wanting to stop you, but the point that I was inviting you to focus on is that it seems to me you're seeking somehow by this submission based on section 19 to say that the minister in charge of a bill speaks for Parliament or is to be taken as speaking for Parliament. And I was pressing you on that because it seems to me that section 19 by no means gives rise to any kind of presumption that the minister speaks for Parliament. In fact, it emphasises he only speaks for himself. He gives his own view.
Well, let me just finish the submission.
Of course, I can be muted now. I've made my point. And you can
I'm perfectly happy to deal with your lordship's observations, but
yes, of course.
The submission is you look at the material of the sort that that Lord Wilson is describing in paragraph 64, A prime example of that material, but not the only example, will be the ministerial statement under section 19. In conformity with the general thrust of Lord Nichols' reasoning, the benign assumption is that Parliament will have acted on the basis spelt out in the sort of paragraph 64 material that is in front of it. It will be a white paper, if there is a white paper, there isn't. It will be the ministerial statement under section 19, if there is one, and there is. We'll see what it says in a moment. The mere fact that some members of Parliament disagree with the minister's reasons for making a section 19 statement is something that can't be investigated under paragraph 67. Simply not what you can do. And if we can make this really fairly crisp, this point fairly crisply, looking at this, at the material that the Secretary's statement has put in. If your lordships and my lady look in the second and third boxes, 20th of July 15, second reading in the Commons, Caroline Harris says, what assessment has been made of the effect of his welfare reforms on the children of this country? Answer from the Minister, the impact assessments are in the library and the vote office. We'll come to those in a moment. They repeat the fact that Mr. Duncan Smith is under the section 19 duty. They state what his views are on compatibility, and they give the reasons for the views. So that in the debate, Parliament is being told the assessment, including the section 19 reasons for viewing compatibility, are in the impact assessments in the library and the vote office. There's then a comment by Angela Crawley about CPAG figures. Now, the rhetorical question for Professor James is, does the government accept that or not? This is an observation made in the course of the debate about the impact of the measure. It's not the government's case. It's simply the sort of observation that Lord Nichols is describing in paragraph 67, not 64, of the judgment in Wilson. And we can make the same point with all the material that my learned friend says was in front of Parliament. The government didn't accept it. That's the whole point. It didn't accept that the legislation was flawed for the reasons advanced by CPAG or indeed by anybody else. It went on the basis set out in the impact assessments which are in the library and the vote office. So the rhetorical question for Sir James, is perfectly happy for him to answer, is does the government accept the perspectives set out by Angela Crawley or Sammy Wilson or Helen Goodman, or does it stand by the impact assessment? It has to do one or the other. And that matters hugely when it comes to Article 3. Article 3 requires the legislative body to treat the interests of the children, ignoring the General Comment 14 or anything like that, just looking at the wording of Article 3 itself, to treat the interests of the children as a primary consideration. That must mean ignoring even General Comment 14, identifying. Let's come and see how they did it. So what were identified as the best interests of the children? Well, the answer is the reasoning set out in the Minister's impact assessment, which he said supported his view, which he's statutorily required to express under section 19. And the same is true of all the other material. It is obvious, if your lordships and my lady go to today's note, that the written submissions from various organisations were compiled into a 283-page document for the Bill Committee. That's paragraph 3, Roman 4, of this morning's note from the Secretary of State. Well, that's true. Presumably the Secretary of State didn't accept them. We do not know how individual members what individual members made of them, because as Lord Nichols points out in paragraph 867 of Wilson, that's an exercise we can't indulge in. So we certainly know that there was a debate about whether this legislation was sensible or not. But the approach for judging its proportionality, in keeping with the analysis of Lord Nichols and Wilson, has to start with the statutory material provided under the machinery of Section 19. And for all we know, the measures were voted through by backbench members on the basis they agreed with the impact assessment. Indeed, that would be the conventional assessment. So the simple fact that there is some dissent, or even a lot of dissent, by members of Parliament doesn't affect that basic issue. If we then go to the impact assessment, one target we have in mind is, of course, Article 3 of the UNCRC, but it's not the only one. It's the issue of also the assessment of proportionality and whether that contains anything to which this court should, as it were, defer on the basis that it expresses the views of Parliament. The impact assessment, the court will find it's in Appendix 2. But actually, I'll probably go first, not to the impact assessment, but to EF 683 in Appendix 2. This is the memorandum to the Joint Committee on Human Rights. And the court will see that it starts, it actually isn't the Section 19 statement. I'm not sure that we've got the Section 19 statement in the papers. But it refers in paragraphs 1 and 2 to Section 19 of the Human Rights Act. It states, Section 19 of the Human Rights Act requires a minister to make a written statement prior to second reading as to the compatibility of the provisions of the bill with the European Convention on Human Rights. The purpose of this memorandum is to analyse the issues arising from the welfare reform and work bill in relation to assessing its compatibility with the Convention. The provisions of the bill are compatible with the Convention, and the Minister has made a statement of compatibility under Section 19(1)(a) of the HRA to the effect that, in his view, the provisions in the bill are compatible with Convention rights. So there we have the Minister in charge of the bill expressing a view that it is compatible. The memorandum goes on to explain why he thinks it is compatible. This is precisely the sort of material which Lord Wilson is dealing with in paragraph 64, but not 67. Sorry, if I said Lord Wilson, Lord Nichols is dealing with it in paragraph 64, but not 67 of Wilson. When we go to look at how it dealt with the best interest issue, your Lordship and my Lady can go to page 696, EF 696, paragraph 76 through to 77. And it does start with the proposition in the first sentence of 76, that in relation to clauses 4 to 6 life chances, the government's position is that in refocusing government action from tackling the symptoms of child poverty to tackling the root causes of poverty, its primary consideration is the best interest of the child in accordance with Article 3. This new direction is more appropriate, making is a more appropriate means to making a real and lasting difference to children's lives, and so on. But then when it comes to dealing in 77 with the clauses that are in play here. They are the clauses in the last 3 lines of 77, clauses 11, 12, due child restriction in child tax credit and universal credit, clauses 13 and 14, etc. Now, what it says, what the passage as a whole says, I'm picking it up about halfway through the passage. Children in workless families are 3 times as likely to be in relative poverty than families where at least one parent works. The cap has been proven to encourage movement into work. Evidence shows that capped households are 41% more likely to go into work after a year than similar uncapped households, so reducing the cap further will encourage more people into work. Savings afforded to the government by reducing spending on welfare will allow the government to protect expenditure on education, childcare and health, and the improvements to the overall economic situation will have a positive impact on children in their best interest. These considerations apply equally to clauses 11 and 12. Now, I've made this point already, but I make it again. The majority of people on child tax credit are in work. The straightforward reference in the respondents' evidence to that is to EF electronic file page 581, first sentence, paragraph 68 of Higlet. The work incentivization, which is at the heart of this passage, has no relevance to the families on CTC who are working, and no relevance, for the reasons that we've already explored, to the impact of clauses 11 and 12 on children. And so to say that the reason why the measures are to be are thought to be in the best interests of the children affected are work incentivization actually makes no sense in the context of this, in the context of clauses 11 and 12, as they then were. And it's precisely for that reason, which Lord Justice Leggett, I think, understood, that he said the executive has paid scant attention to the best interests of the affected children. That's true. But it goes further than that. When one carries out the Lord Nichols analysis, as displayed in Wilson, what Parliament is being invited to do by the majority party and by the minister in charge of the bill is to enact the legislation on the basis of the proportionality appraisal contained in the memorandum which we're now looking at. Now, some people disagreed with that. Some people disagreed strongly with that. But it was so simply contrary to the whole basis on which Lord Nichols asked them to approach the thing to treat the dissenting views as somehow expressing the basis on which the legislation has been enacted. Now, I should in completeness say that your Lordships and my lady will also find in paragraph 41 a more general description, not related to best interests of the children, it's EF 691, of the thinking behind the bill. And your court can read paragraph 41. And the last 4 lines include a reference to the same financial decisions argument. So that does form part of the reasoning why the minister thought the bill was compatible. But the sole reasoning in relation to Article 3 is contained in the second part of paragraph 77. So my submission, where we come back to, is that I accept the court must judge the compatibility of the legislation for itself. But in doing so, it has to look at the broad picture which I tried to spell out, in particular, the irrelevance of the aims to the affected children, aims of work incentivization and choice of affected children. Bear in mind what we have said about the impact of this particular structure of benefit changes on women, uninformed by any influence to be drawn from the debates in front of Parliament. They were based on an analysis contained in the memorandum that we've been looking at, which is simply flawed. Well, not just simply flawed, it doesn't deal with Article 3 in any satisfactory way at all, or indeed more generally with proportionality in any very satisfactory way. When you do that, we do ask the court to say that the measures are have a disproportionate impact in the way that we've identified in the case. I repeat the simple fact that the ministerial case wasn't accepted by all members of Parliament is neither here nor there. That is precisely what Lord Nichols told us. So those are my submissions on the approach to the parliamentary material. Note that Professor James hasn't said that he agrees with everything that CPAG said in the course of the or that his instructions are that CPAG was completely right on everything. You didn't see a smile. That's the necessary logic of the case. I mean, the case has to be that Parliament didn't act on the memorandum, but did act on the views of the opponents to the memorandum. That is not a satisfactory analysis. That's the fundamental focus of the reply. I have some other shorter points. There's obviously a major issue about the test of manifestly without reasonable foundation. Sir James said I had dealt with this with a forensic light touch in opening. That's correct. And I don't want the court to come away with the impression that I spend my whole life arguing about what the right test is in convention cases. I, in fact, appeared in STEC, RJM, DA, JS, MA, Carmichael. This is the first time I've ever made a submission on what the right test is. And I want to, in closing, just to make one submission about the manifestly without reasonable foundation test, which is that it might be thought that the problem is actually in the label. The word manifest and foundation, which cause the problems and maybe what causes it to keep on coming back time and time again. The non-offence printed case accepts that it's necessary to look at proportionality in each and every one of the 4 stages identified in Bank Merit. And obviously, we are highly concerned that the court stays with the analysis of Lord Justice Leggett or something like it's a similar analysis of Lord Justice Hickinbottom in the JCWI case in paragraph 89 of the judgment. As I understand it, having reread with some care the learned friend's printed case, he doesn't dissent from the test in paragraph 89. Now, if the test in paragraph 89 is correct, you are not asking, is there a rational reason for the discrimination? You are asking at the 4th stage whether the difference in treatment is manifestly disproportionate to legitimate aim. Particularly that manifestly have their own difficulty, but that is the test. If you're not going with Strasbourg on JDNA, you are recognizing that there's a margin of appreciation or degree, in domestic terms, a degree of deference due to the executive in its financial appraisals and formulation of economic policy and so on. But when you get to the stage where there's a manifest disproportionality, then the court say so. Similarly, as we saw in, I think it's paragraph 73 of Lord Tilson's judgment in Carmichael, if you get to the stage of finding that an impact on someone in one of the sensitive classes, sex or race discrimination, for example, if there's a major impact on that, then you say it's manifestly without reasonable foundation. See, Lord Tilson, I repeat, it might be thought to not make much difference whether the approach is either the Strasbourg approach or paragraph 89. The strategic submission I wish to raise is that your Lordship should clearly endorse, if you're not going with JD&A in Strasbourg, should clearly endorse paragraph 89 or a similar approach in JCWI, because it's quite a common experience for advocates arguing about social policy to find the court at lower levels saying, well, the test is manifestly without reasonable foundation. Here's the reason for it. That's not going to be unreasonable. It must therefore be good enough. But that, in my respectful submission, is not what the test requires. The approach in 89 struggles with the language of manifestly without reasonable foundation and comes up with an explanation for it. It might be simpler just to say what the mental exercise actually is. And that's what I would like the court to do. But that's the only, that may not, I don't know if it's a forensic light touch or not, but that is the submission on manifestly without reasonable foundation. On the other issues, we essentially say, well, we do say, that the judgment of Justice Leggett is correct in its analysis of ambit, dealt with in paragraphs 55 to 59 at EF 216 to 217. That's dealing with Article 8. Similarly correct in its analysis of the ambit of A1P1 in paragraphs 47 to 52 of Mr. Lord Justice Leggett's judgment. And similarly, what is correct as to status in paragraph 70 to 78 at EF 232, to reinforce the perspective of Emerson Lady Black's question about the reference to the French text. RJM, of course, was a case in which there was a major attempt by me to argue that the case law of the Strasbourg court did not require any analysis in relation to personal characteristics or anything like that, because there are many examples where Strasbourg has dealt with, for example, limitation period, simply by asking whether the differential limitation periods were reasonable, not looking at all at the background material. There's nothing revolutionary in the approach to status. We say that Lord Justice Leggett got it right in paragraph 70 to 78, and especially at paragraph 76, which the court was taken to by one of friend in his file number 222. Look, ladies, those I think are my submission. Anything else I can help the court with?
Well, thank you very much, Mr. Drabble. We're grateful, we're very grateful to all counsel to the quality of the submissions that we've received. What I think we all would agree is a very important case. We'll now take time to consider our decision. As with SAT 7, it may take longer than usual to produce judgments. That's the general experience. But we'll take such time as we need. Thank you all very much. The court will adjourn.